Hello friends, Namaskaram. There are multiple queries. How we could give reply to a notice served as per the protocol of section 138 of NIAT. So steps are quite simple. I will explain you in detail how you could defend and how you could reply. So basically we are moving on the screen and try to conceptually clear yourself and then note down the points so that if you are having the trouble, you could easily encounter the same without getting any panic or trouble. So directly we are moving on the screen. Whenever a reply is given to a notice which is served as per section 138 of NIAT, we have to understand certain principles. Number one, the reply is to be given within 15 days from service. Number two, reply must be specific, not general. If reply is general, in that scenario, it will be hit by Order 8, Rule 4 of CPC. At inception, we have to give a simple denial. And we have to mention that all the facts mentioned in the notice are false, fabricated, and concocted. And we deny the existence of them. There is no legal enforceable debt or liability against us. Present notice is abuse of process, hence liable to be discarded on that point as well. So it is called a simple denial, which is also must. And after that, we have to work out on the point of legal enforceable debt. That is called a specific denial. If there is no legal enforceable debt, in that scenario, we could have the benefit because legal enforceable debt is sine qua non for prosecution as per section 138 of NIAT. And apart from that, there is no presumption of the debt. The debt is required to be proved by the complainant, but we have to suspect on the existence of the legal enforceable debt. For example, if Mr. A says that I have given to Mr. B rupees 2 lakh as loan. To pay the amount, he has issued the check. Finally, it is dishonored, and that's why notice is given. In reply, Mr. B says that the money is repaid, and in support of his specific defense, he encloses the specific defense or evidence with reply. In that scenario, he is going to chalk out a suspect on the existence of legal enforceable debt. So, if there is no amount due in that scenario, the legal enforceable debt goes out, and ultimately, the concerned person could have the benefit. It is called the specific defense. Sometimes there is a possibility that check is given towards security. It is called PDC. In PDC check, the liability is in existence. To claim the benefit, we have to show that it is towards the indemnity or security regarding the performance of contract. If there is no specific pleading or evidence by us, and simply we say it is a PDC check towards the amount, in that scenario we could not be succeeded. We have to show the misuse of check. We have to show that it is towards the indemnity, towards the security regarding the performance of the contract, and ultimately it is misused by the concerned complainant. In that scenario, we could be succeeded. And apart from that, if the concerned account does not belongs to you, or you are not the drawer of the check, you could take the specific plea. In part number 5th, we have to specify the material concealment of the facts. For example, if Mr. A says, I have given rupees 5 lakh to Mr. B towards a loan. To pay the amount, Mr. B issued a check. It is dishonored. But Mr. B says that I have repaid the part amount, that is rupees 2.5 lakh, but there is no endorsement of that amount. In that scenario, it is a case of material concealment. And finally, Mr. B could be succeeded if the said ground is available. Apart from that, there might be a situation regarding the cause of action. For example, if notice is given to Mr. B, but the specific difference is that the check is issued on behalf of company and company is not made party, there is violation of section 141 of NI Act, and ultimately Mr. B could be succeeded. So we must know that a check case is the technical offense. If there is any technical illegality, I'm going to specify on the part of complainant, then the concerned accused could have the benefit. Basically, whenever we are going to reply, we must understand that reply must be as per the angle of section 143A, section 139, and section 118. If our reply is not having the probabilizing effect, and apart from that, it is not a probable defense, then we could not be succeeded. We are not supposed to prove our defense beyond reasonable doubt, but our defense must have the probabilizing effect. It is a requirement. And apart from that, there might be a case wherein the person who is going to file the case is not properly authorized. For example, company Messrs A Private Limited authorized Mr. A to file a prosecution of check bounce against Mr. B, but there is no power of attorney, even there is no authorization on record to sustain the proper delegation. In that scenario, Mr. B could have the benefit. So each case has its own merit. So we have to give the specific reply. If our reply is general, it is not specific, then we could not be succeeded. You got my point now? And apart from that, we have to specify in which manner the check is misused. And apart from that, we have to specify the legal consequences which will be faced by the concerned complainant. Please be noted. Regarding the misuse of the check. And apart from that, we have to specify that the notice is to be withdrawn by the concerned complainant. Otherwise, the proceeding as per law will be initiated against him. So, in that manner, we have to specify or we have to give our reply accordingly. So, in nutshell, we could say that our reply must be specific. The story of prosecution or complainant must be rebutted in toto, and the specific defense must be on record to create the probabilizing effect. Otherwise, we could not be succeeded. So I think that in simple words, I have clarified you each and everything so that if you are having the trouble, you could easily encounter the problem without getting any anxiety or panic. See you in the next lecture.